Mr. Blundell, can I turn to you now, please, to make your submissions on behalf of the Secretary of State?
My Lady, thank you very much. My Lady and my Lords, the single issue to which this case gives rise is the test to be applied when determining whether a beneficiary of a Zambrano right to reside may be deported. To be clear, there is no dispute between the parties about the fact that a member state may deport such an individual. The only question is as to the test to be applied to decisions to do so, and specifically whether a test of exceptional circumstances applies. The Secretary of State's position in a nutshell is that no test of exceptional circumstances applies. The source of the suggestion that such a test applies is a single use of the phrase in exceptional circumstances by the Grand Chamber of the Court of Justice in its conclusion and then repeated in its dispositif in its judgment in the case of CS. But read properly and in context, we say it is clear that the Luxembourg Court was not applying a test of exceptionality or a higher threshold of some sort at all. Rather, the use of that phrase indicated merely that the making of a deportation order, or in the language of the Luxembourg Court, an exclusion order, was permissible under Article 20 of the Treaty on the Functioning of the European Union as an exception to the usual application of the Zambrano principle, provided, of course, that sufficient grounds of public policy or public security could be established. And we say structurally within the judgment, one sees that from the use of the reference to an exception in paragraph 36. We make that submission for three reasons. First of all, we say it is evident from a proper reading of the passages on which the appellant relies in CS in their proper context. So it is supported by a proper textual analysis of the court's decision. Secondly, it is also supported, we say, by a proper reading of the two other decisions of the Grand Chamber, which have examined the issue of derogations from the Zambrano right in principle. That is, of course, Rendon, Marin and KA. So authority supports the reading of the Secretary of State's decision in CS. And thirdly, it is supported by the context in which CS was decided. That is, the starting point is that a Zambrano right of residence is a derivative right of residence. Article 20 TFEU, its legal basis, is not a source of autonomous rights for third country nationals. Any rights derived from that source are and are only granted so as to make an EU citizen's rights as an EU citizen effective. And specifically, in the Zambrano context, all this is done in order to protect the potential future exercise of free movement rights. It is not done to reflect free movement rights that have already been exercised. Indeed, one of the important contextual factors is that EU citizen children may leave the territory of the EU for a whole host of reasons, all stemming from the fact that their presence depends entirely on the exercise of parental authority. So while the protection of their ability to exercise free movement rights in the future is of course important, it cannot ignore the limitations which exist for them in any event. So we say text, context and authority all support the Secretary of State's position in this case. Against that background, what I was proposing to do, if it assists the cause, is to begin by analysing the court's judgment in CS. That's the textual point. Then I was going to proceed to examine how the court has dealt with the principle in the other authorities, Brendan Marin and KA. That's the point about authority. And finally, I was proposing to look at some of the contextual issues arising from the way that the appellant puts her case. That's the point about context. So against that background, may I begin by turning to the decision in CS itself. And I do appreciate that the court's already seen this in some detail this morning. So I'll take it as quickly as I can, but I want to just go through it again to make some points about the structure of the judgment and how the points came to be decided as they were. The court will have it in volume 1 of the authorities bundle behind tab 9, beginning at EF page 498. The court will be well aware of the fact, of course, CS was a Moroccan national with ILR and a British citizen child. She committed a criminal offence, received a 1-year jail sentence, and was made subject to a deportation order. The father of the child was not able to care for it. So it was, in that sense, a classic Zambrano situation. The child, if CS left, would have to go with her. But unlike the classic Zambrano situation up to that point, CS, of course, had committed a criminal offence. Can I begin by just asking the court to look at the questions that were referred? I don't think you've seen that this morning. That's at page 505, paragraph 19. And the court will see that there were 3 questions referred by the upper tribunal in this jurisdiction. First of all, the first question asks the question of principle. So can a member state deport a third country national at all, where they would otherwise qualify under the Zambrano principle but have committed an offence? I should say, to make clear, the primary argument being advanced by CS in this case, and indeed supported by the European Commission, was that it was not possible to derogate from Zambrano at all. And that, the United Kingdom government argued, would have created a unique species of EU residence right from which no departure was possible. Equally, the United Kingdom government had started by arguing that EU law wasn't engaged in a situation of criminality. So the positions were quite extreme. But CS also adopted as a fallback argument an argument that the imperative grounds of public security test should apply by analogy. So that perhaps puts in context some of the material in the Advocate General's opinion. But the positions were rather stark between the parties. Question 2 then builds, of course, on question 1 and asks in what circumstances a derogation could occur. And question 3 indeed builds on question 2 by examining the extent of relevance of Articles 27 and 28. Again, perhaps relevant when one comes to examine the use that was made or the adoption that was made of certain parts of those provisions in the judgments themselves, and of course in the Advocate General's opinion as well. But as is not uncommon in the Luxembourg court, the court rephrased the questions to try and focus on the key issues as it saw it arising within the context of the case. And that reformulation is at paragraph 20. Can I just ask the court to read paragraph 20? I'm very grateful. The reason why I asked the court to read paragraph 20 is that the reformulation is quite significant, particularly in responding to a point that Mr. Southey's relied on quite heavily, both in his written case and indeed orally today. What the court seems to be suggesting in paragraph 20 is that it's looking at legislation which, to use its own language, requires a third country national who's being convicted of a criminal offence of a certain gravity to be expelled. So the court's analysis, at least at this stage of the case, and I'll come to look at how it reformulates it again later on, is that it's looking at legislation with very much similar effect to the legislation that Mr. Southey's pointed you towards in the Rendon Marin case. Now, that may or may not be a correct analysis of the UK Borders Act 2007. Of course, there is an exception in the automatic deportation regime where EU rights would be breached. But in terms of the way the court was looking at it, it certainly had that approach on the legislation very much in mind. So when Mr. Southey says, well, a key point of distinction between Rendon Marin and CS is that in Rendon Marin, the court was looking purely at legislation that had an absolute effect, whereas in CS, it was looking at a much more fact-specific issue. That's not quite right if one looks at how the court was actually describing the legislation as it saw it, rightly or wrongly, in its reformulation of the question there. So my submission, just worth having that point in mind when one considers Mr. Southey's point about the comparison between the two cases. I've already indicated that the UK had begun by advancing what might be thought a rather bold argument that EU law wasn't even engaged in a situation of criminality. That effectively is what leads then to the discussion in paragraphs 20 through to 33. One sees really the analysis and the conclusions being drawn on that argument at paragraphs 31 to 33. And I won't go through those, the court has already seen them, they'll be well familiar to the court. But then really the critical part of the court's reasoning begins with paragraph 34 under the heading, the possibility of limiting a derived right of residence flowing from Article 20 FEU. Not discouraged by having lost the argument about EU law not being engaged, the UK government has a second try at arguing that the Zambrano principle at least wasn't engaged in a situation of criminality. So in other words, it sought to confine the application of Zambrano very much to its own facts, because of course Mr. Zambrano was guilty of no criminality at all. That's what one sees at the beginning in the first sentence of paragraph 34. But then the UK's fallback argument was that if, however, the principle was applicable, then it was capable of limitation, and you'll see some reference then in 35 to Articles 27 and 28 of the directive. So very much in play. That then leads to what I will term the first of two key staging posts in the court's analysis at paragraph 36. And one sees there at the outset of paragraph 36, the court saying this: it should be pointed out that Article 20 FEU does not affect the possibility of member states relying on an exception linked, in particular, to upholding the requirements of public policy and safeguarding public security. The court then goes on, of course, to refer to the need to take into account Article 7 of the Charter and the child's best interests. But this, in my submission, in a sense, is the beginning and end of this issue. This is the only reference to an exception or anything like that sort of language in the main body of the judgment. It is quite clear that what the court is doing at this first primary staging post stage is to say that, yes, it is possible to derogate in principle from a derivative right of residence under Article 20 on the Zambrano principle. It doesn't tell you at that stage what the test is, although it does refer to upholding the requirements of public policy and public security. So there's a hint of it there. But the key finding at this stage is that it is possible to rely on an exception. Of course, that was the key issue for the first question. And without that, one wouldn't get into all the debate about what the test was. Now, just to pick up on paragraph 37, which follows, an argument this morning, my Lord Sales, I think, pointed out that this might be seen as indicating a particularly restrictive approach to derogations from the Zambrano principle based on the court's existing case law. We would respectfully entirely agree with that analysis. That is the position. The Secretary of State's position in this case is not to adopt the complete converse of Mr. Southey's argument. We're not arguing that it is particularly easy to deport somebody who has a derivative right of residence. That's not the case. And this court, in the Nouasley decision, has already found at paragraph 30, and for reference, that's Authorities Bundle 1, tab 4, page 282, that those who have EU law rights of residence already have the benefit of powerful protections against expulsion. So that's very much the same flavour, same theme that one sees in paragraph 37, with the court saying that any exceptions cannot be unilaterally determined. The scope of the public policy and public security grounds cannot be unilaterally determined by the member state. So it's a strict construction that's applied. And there's obviously plenty of authority cited for that particular proposition. Then there's analysis of the application of that particular exception in the paragraphs which follow at paragraphs 38 through ultimately to 50. But the next key paragraph in my submission, or I should say, actually, paragraphs 38 and 39 make reference to the court's established jurisprudence on the scope of the public policy and public security exceptions. Unsurprising, because they've already been raised within paragraph 36, and I'll come on to them and how they're dealt with as it goes on. But striking, we say at this stage, that there's no reference, by contrast, to any of the court's case law on the imperative grounds test. If that was truly the test, we would expect to see it here, or in some of the paragraphs which follow. There is case law on it. So the second, then, of the two key staging posts that I referred to just a moment ago is at paragraph 40 of the court's judgment, where the court says this: in this context, it must be held where the expulsion decision is founded on the existence of a genuine, present, and sufficiently serious threat to the requirements of public policy or public security in view of the criminal offences committed by a third country national who's a sole carer, children who are union citizens, that decision could be consistent with EU law. So confirmation, we say at this second stage of what the test is, it's the ordinary application of the public policy and public security tests, coupled with the requirement, as usual, to demonstrate a genuine, present, and sufficiently serious threat to those legitimate interests. So to pause there, one has key staging post number 1, paragraph 36. Yes, in principle, you can derogate from a Zambrano right. Then at paragraph 40, key staging point post number 2, the test for that is genuine, present, sufficiently serious threat to a legitimate interest of public policy or public security. And then what follows from that in the following paragraphs is guidance to the referring court, indeed more generally to the member states and member state courts, about how to apply that test. So one sees at paragraph 41, the court's conventional, very well established by this point, statement of principle that you cannot draw that conclusion of a threat to the legitimate interest merely from the existence of a criminal conviction. What you have to carry out instead is a specific assessment. Then there is reference in paragraph 42 to what that specific assessment must examine, so length and legality of residence and so on and so forth, effectively degree of integration. And then at paragraphs 43 and 44, the court makes reference again to the domestic legislation. Perhaps worth just flagging paragraph 44. It says the legislation therefore seems to examine a systematic and automatic link between the criminal conviction of the person concerned and the expulsion measure, or in any event there is a presumption that the person concerned must be expelled. So again, very similar analysis to the analysis in Rendon Marin. Perhaps the court stepping back slightly from the full Rendon Marin situation by referring to the presumption here, but no real engagement with the degree to which the presumption works in domestic law when there is a breach of EU rights. There's then a repetition of the point that the mere existence of a criminal record can't be enough to justify the expulsion decision. And then more detailed guidance at paragraphs 46 through to 49. Perhaps again, I can just ask the court to read those passages. I'm grateful. So just perhaps to summarise on those passages, paragraph 47, we say these are important passages, particularly for member state courts in understanding what it is the court requires of them when examining these rights and derogations from them. Paragraph 46 explains how to examine the criminal conduct in question to determine whether that satisfies the genuine, present, sufficiently serious threat test. Paragraph 47 then develops the point about the develops the point of a balance, or rather the balance comes in paragraph 48, but paragraph 47 requires you particularly to take into account on one side of the balance the danger to society from the criminal conduct and the consequences for public policy and public security. One gets to the other side of the balance in paragraph 48 and indeed paragraph 49 with a reference to fundamental rights, private and family life, and of course the child's best interests coming up in those passages. All of that then leads to the summary of conclusions in paragraph 50. And I pause here to say this is exactly that. It's a summary of the court's reasoning so far. Again, in a completely usual way for a decision of the Court of Justice. There's no new or additional reasoning in this passage, or indeed in the dispositif which follows it, and which is in identical terms. So in order to understand what this means, one has to understand what comes before, which is why structurally I've gone through those passages in the judgment again, one has, of course, the reference to exceptional circumstances in this passage. But the only passage in my submission which that could possibly refer to in a material which came earlier is the first key staging post at paragraph 36, which is a very important staging post because it answers the question of principle, can you derogate at all? This part of paragraph 50 is saying, yes, you can. You can have an exception. And that's what that means. There's no other trace of the language of exceptionality anywhere else in the judgment. That must be what it's referring to there. So that's why we say textually that is dealing absolutely with an exception, not an additional test of exceptional circumstances. And we also say, read in the context of what precedes it, of course, that's supported by the absence of any reasoning as to exceptionality, or indeed the absence, for example, of any reasoning on the imperative grounds test, which is the other way Mr. Suddy puts his case. So for all those reasons, that's how we say CS should be interpreted. First of all, it answers the question of principle, can you have an exception at all? Yes, paragraph 36. Secondly, what's the test? That's answered in paragraph 40, genuine presence and sufficiently serious threat to one of the legitimate interests of public policy and public security. Perhaps just before leaving CS, I should just also flag in response to a question that was asked this morning by my Lord Jones as to the different language versions. Like I think Mr. Suddy, we also did review some of the language versions to see if they cast any light on it. I'm afraid our view was that they didn't. We checked the French, the German, the Italian, and the Spanish versions, and they all used what appeared to us to be equivalent phrases. Circonstance exceptionnelle in French, außergewöhnlichen Umständen, I think. Looking at my junior, she confirms that's the case in German, and similar phrases in the Italian and Spanish. What they don't contain is any explanation of what that phrase actually means. So one is in exactly the same position as if one reads just the English language version. I hope that's of some assistance. So, my lady, that's what I was proposing to say about CS. Obviously, there's the Advocate General's opinion, which I will come to after I've looked at RM. It seemed to me to make sense to do it in that order. But I was proposing now to move to my second main submission, which is authority, beginning with RM and then moving to KA. So RM, again, the court's seen it this morning. It is in tab 7 of Authorities Bundle 1. Same key issue of principle arising, albeit in a slightly different context. It was to do with the application, as Mr. Suddy has shown you, of Spanish legislation, which certainly did operate in an absolute way and required residence permits to be rejected, applications for residence permits to be rejected where there was any criminality on the part of the applicant. Mr. Rendon Marin was a Colombian in Spain. He had slightly unusually 2 children with different nationalities within the state. So he had a Polish daughter and a Spanish son, but neither of them had ever left. And there weren't any other parental figures who were present to take care of them. So in that sense, he was in the classic Zambrano situation, although as the court will have seen, because of the presence of a child with a different nationality there were also issues around Chen derivative rights, but I needn't trouble the court with those today, that they're a different issue. Can I take the court straight to the key passages which begin at paragraph 81 of the court's judgment, and that's at page EF 440. Again, one sees the heading towards the bottom of the page, letter H, the possibility of limiting a derived right of residence flowing from Article 20 FEU. And you will see then in paragraph 81, the equivalent of paragraph 36 of CS Morocco. Article 20 doesn't affect the ability or the possibility of member states to rely on an exception linked to public policy and public security, but then requires an assessment of his right to respect for family and private life in Article 7 and the children's best interest in Article 24. Some of the reasoning which follows then is somewhat more condensed than in the CS judgment, but only marginally. One then has the second key staging post equivalent in paragraph 84, where the court holds that in this context, where a refusal was based on the existence of a genuine present sufficiently serious threat, so on and so forth, that could be consistent with EU law. So again, that's the equivalent structurally of paragraph 40 in CS Morocco, exactly the same approach being taken. And again, similar, albeit more condensed, reasoning follows from that in paragraphs 85 and 86 as to the issues which have to be taken into account. And then in paragraph 88, one gets a judgment, again, which makes no reference at all either to an exception or to exceptional circumstances, nor does it make any reference whatsoever to imperative grounds of public security test. So at that stage, can I just draw the strands together before I visit the Advocate General's opinion on the two judgments of the court? And really, there are four submissions I just want to make here. First of all, it's clear that the analysis in the two cases, in the passages which actually analyse the dispute in issue, is identical and includes the same two key staging posts: existence of an exception in principle and then test. Secondly, in each of CS and RM, both in the conclusions and the dispositif, the court simply summarises what precedes it in the body of the case, in the body of the judgment. It does not introduce any new test or analysis. So if one's looking at what the conclusion and the dispositif means, one has to source the conclusions back into the text of the judgment. That's why I make the link between exceptional circumstances and para 36 in CS with an exception. Thirdly, the court's reasoning in those relevant passages contains not a hint of an exceptional circumstances test. And fourthly, in our submission, that cannot simply be explained away by the particular legislative backdrop in Rendon Marin, given the way that the court analysed the domestic United Kingdom legislation in CS Morocco, see paragraphs 20 and 44 of that decision. So, my lady and my lords, while I'm there, can I just then go back to deal with the Advocate General's opinion in Rendon Marin? There's only really one passage I need to take the court to. Again, I'm grateful to Mr. Southey for having set out the context of the Advocate General's opinion in more detail this morning. I don't need to revisit most of that. The one key passage, because it's the only passage where there's any reasoning on this point, is paragraph 168 at page 418, using the electronic filing numbering. And of course, what the Advocate General says there is, in the present case, given that the minor child might, as a consequence of the expulsion of the mother, temporarily have to leave the EU altogether, it's appropriate he should be accorded the enhanced protection implied by the term imperative grounds of public security. Accordingly, only imperative grounds of public security are capable of justifying the adoption of the expulsion order against S if, as a consequence, her child would have to follow her. So he's making that conclusion specifically in relation to CS case. It then reappears in what he terms as interim conclusion on that case at paragraph 177 at page 420 of the electronic bundle numbering, and that's it. There's no more explanation for why that test should be adopted. That is all there is. What is, of course, striking from that passage is that that is not what the court does. Can I make 4 submissions on that particular point? So first of all, this is not the language at all of the Court of Justice in either CS or Rendon Marin, the two judgments linked to this joint opinion. Nor, I would add, is it the language, of course, of KA, and I'll come to that in a moment. So if you're being asked to say that this is the test being applied, it must be applied by implication or by inference. It's not adopted expressly. It doesn't feature anywhere in the decisions of the court. Secondly, this is not a case of incorporation by reference. So the court will, of course, be very familiar, I appreciate, with many cases where the Court of Justice says by reference, we adopt or we agree with the reasoning of the Advocate General, whoever it is, in paragraphs, whatever they are, of the particular case. No hint of that here. So this is not a case where one finds any reference to incorporating this analysis without actually repeating it in the judgment. And thirdly, nor is this a case where the analysis in paragraph 168 is necessary to understand something that the court has said in its own reasoning, in its conclusions, which follow. So it's not the case that Mr. Southey, in my submission, can point to any passage in either CS or Rendon Marin which can only possibly be explained by what the Advocate General has said in paragraph 168. They can't. But indeed, the point goes further than that, and my fourth submission on this issue is that actually paragraph 168 is entirely inconsistent with the test which the court did in fact adopt in CS and Rendon Marin. That is for the simple reason that the test as adopted in both those cases in the court judgments makes reference repeatedly to both public security and public policy. The imperative grounds enhanced threshold in Article 28.3 of the Citizens Directive, which is where this analysis comes from, applies only to public security. And it might just be worth turning that provision up. It's in volume 1 of the authorities behind tab 1. Article 27 and 28 are in chapter 6, which deals with restrictions on rights of entry and rights of residence on grounds of public policy, public security and health. Article 28 is at page 226, electronic filing number. And perhaps just worth seeing how Article 28 works. Article 28.1, the whole article is titled Protection from Expulsion. So you begin with paragraph 1 saying that before an expulsion decision on grounds of public policy or security is taken, the host member state has to consider certain matters. So some guidance and some detail there, again, very familiar. Paragraph 2 is the first level of enhanced protection. So the host member state may not take an expulsion decision against union citizens or their family members, irrespective of nationality, so a broad application, who have the right of permanent residence on the territory, except on serious grounds of public policy or public security. So that's a right which one acquires after 5 years lawful residence under the directive. Then, paragraph 3, an expulsion decision may not be taken against union citizens. Pause there, union citizens full stop, not union citizens and their family members irrespective of nationality. It's a much more limited scope of application, a much more limited gateway to go through, because it only applies to EU citizens. That's why, of course, it wouldn't apply to a Zambrano carer, who is by definition a third country national. So it can only be taken against those individuals, except if the decision is based on imperative grounds of public security. I pause there, not public policy. So it's narrower again. It only applies in a public security context. So it would be impossible for the court to have given the reasoning that it did relating to public policy if it was applying this enhanced test. And then if they either A, have been resident for 10 years, or B, are a minor, except if the expulsion is necessary for the best interest of the child, as provided under the UNCLC. So that's where the reference to a minor comes from. But in order to understand why there is enhanced protection for minors, one has to turn back to recital 24, same tab, but on page 196. Can I just ask the court to turn to that momentarily? And the court should see at the top of that page, recital 24, says this: accordingly, the greater the degree of integration of union citizens and their family members in the host member state, the greater degree of protection against expulsion should be. No surprises there. Only in exceptional circumstances where there are imperative grounds of public security should an expulsion measure be taken against union citizens who've resided for many years in the territory of the member state, and particularly where they've born or resided there throughout their life. In addition, such exceptional circumstances should also apply to expulsion measure taken against minors in order to protect their links with their family in accordance with the UNCLC. Well, of course, in a Zambrano removal situation, by definition, the family link is not what's being attacked, because the family is moving as a unit, or at least the parent with care of the child is moving. So that enhanced protection as a matter of principle and justification is not required in a Zambrano removal situation. So there are a number of different reasons why, A, the court would not have adopted this analysis, none of which are explored at all, with great respect, by Advocate General Spunar. And secondly, why, if it had adopted that analysis, it would in fact be completely inconsistent with the express analysis it did adopt. My lords, that's what I was proposing to say about the Rendon Marion case. That just leaves me on my second submission about authority with KA. Can I deal with that very briefly? This is the third and most recent in the trio of Grand Chamber cases examining the issue. The court will find it, same bundle, tab 6, begins at page 319. Judgment, I should say, just to give the court some context, judgment in KA was handed down by the Grand Chamber on the 8th of May 2018. The Court of Appeal's judgment in this case was handed down on the 2nd of February 2018. So the Court of Appeal had examined many of the issues that arise in KA, both the issue as to exceptionality, the issue as to imperative grounds, and also an issue that doesn't arise on this appeal anymore about the Boucherer exception, all of which were examined by the Court of Justice Grand Chamber in KA, but judgment was only delivered after the Court of Appeal. Again, it involves a number of individuals with putative Zambrano rights who were subject to return decisions with entry bans, both adults and children. They made applications for family reunification in country, but they were not considered, and they wouldn't be considered until they had left the state. Can I go straight to the relevant passages, which begin at paragraph 90 of the court's judgment? And again, I'm sorry, that's at page 374, electronic filing numbering. One sees it appears in a passage beginning with the reasons for the entry ban above paragraph 85. Paragraph 90, as regards secondly the fact the entry ban is due to public policy grounds, the court has previously held that Article 20 TFEU does not affect the possibility of member states relying on an exception linked to upholding public policy and safeguarding public security. But of course, it's necessary to take into account Article 7 and Article 24 rights. Again, same starting point, repeated expressly from CS and Rendon Marion, and both those cases are cited as authority for that proposition at the end of paragraph 90. The start of 91, there is really a reiteration of the point that my Lord Sales picked up in paragraph 37 of CS, which is that as a justification for derogating from rights of residence, public policy and public security must be interpreted strictly. So nobody's saying this is an easy test. It's not easy to deport people with EU law rights. It's very difficult. And that's what the court is picking up here. There's then an analysis in the remainder of 91 of what the concept of public policy imports and requires. I pause there to say, of course, if the imperative grounds test applied, this reasoning would be impossible. And then paragraph 92 is effectively a recitation of the second key staging post in CS, paragraph 40 of that judgment, pointing towards the requirement to demonstrate genuine presence, sufficiently serious threat. And then the reasoning which follows, again, mirrors the reasoning in the two earlier cases. And that's all brought together then in paragraph 97 of KA. So in my submission, completely consistent with those passages. Can I make 4 key submissions on this case? First of all, the court starts with the same first key staging post as in CS and RM, namely acceptability in principle of an exception being made. Secondly, it takes forward also the second key staging post in its paragraph 92, namely the tests that I've already referred to. Thirdly, to summarise, the guidance in substance to the referring court is the same as in CS and Rendon Marion. And then fourthly, again, no trace in any of these passages, not even a hint in the summary conclusion at 97 of any sort of exceptional circumstances test. It might be understandable if the court had omitted to develop that sort of test on one occasion, but not 3. It is the Grand Chamber repeating carefully its analysis, carefully developed in the earlier cases. It is, in my submission, quite clear what it is doing there, and it is not adopting an extra additional threshold or an additional test, which is not actually spelt out in the judgment. So, my lady and my lords, pausing there, bringing this together at this stage on the second submission that I make about authority, CS starts by showing that there's no textual support for the appellant's argument. Nothing to do with exceptionality at all there. The other authorities, Rendon, Marin and KA, do not assist the appellant either. They're completely consistent with the approach in CS. And then thirdly and finally, there's no support in the Advocate General's opinion in Rendon, Marin for the proposed imperative grounds test. It's simply not adopted by the court. That often happens. In terms of the Advocate General's opinion in KA, I wasn't proposing to go to that, except just to say, indeed to pick up a point made by my Lord Stevens. As Advocate General Sharpston pointed out in that case, it was appropriate to adopt some, by analogy, some of the protections in the Citizens Directive, but she expressly didn't adopt all of them. And the imperative grounds test is a very good reason for that. There is a sound reason for the court not having adopted that particular aspect of the Citizens Directive by analogy. It would have been a singularly inapt analogy in the circumstances of the Zambrano case. So, my lady, my lords, that's what I was proposing to say on the second submission about authority. Can I then move to deal with my third and final key submission, which is about context? And what I was wanting to do under this head is to pick up three remaining contextual points made in Mr. Southey's submissions today and in his written case, some of which I've touched on already in the analysis of CS and Rendon Marin, but I'll go back to in a little bit more detail now. And the 3 points that I was going to respond to were Mr. Southey's arguments that, first of all, what is at issue is not the rights of the appellant, but those of her EU citizen son, and he should not be held responsible for her conduct. So it's a sort of don't visit the sins of the father on the child argument. The second point I was going to respond to was the appellant's argument that one should apply the same test to a Zambrano carer who's being deported as to an EU citizen child to an Zambrano carer with an EU citizen child suffering an indirect deportation, as is applied to an EU citizen child suffering a direct deportation. I'll come back to why that's not appropriate in a moment. And then thirdly, the point Mr. Southey makes that what's an issue is the right of an EU citizen child to remain in the state of which he or she is a national. I think that was developed at the outset of his submissions today by reference to the submissions on the right of residence as well as the right of free movement. Again, I'll explain why that, in my submission, does not help the appellant in this case. So can I deal with the first of those points? That the child should not be responsible for the conduct of the parent. Well, of course, put like that, I cannot but agree with that submission. Of course, the child isn't responsible for the conduct of the parent. But what the appellant actually seeks to do by that submission is to argue for the converse proposition, which is that a member state can never take action which may have consequences for the child where the action is directed against the parent. And that is simply not correct. And that's not supported by any of the authorities that are relevant. It's not supported by the law. The court, in the context of Zambrano case law, has always been quite clear that the particular position of a child and a child's best interests have properly to be considered. That's clear from the Zambrano decision itself. I've not gone back to that. Mr. Southey's taken you to it. It's clear what it says and the court's very familiar with it. But that's been developed in, for example, Chavez-Vilches and the later cases, the Patel and Shah case, in this court that Mr. Southey referred you to earlier this morning. It's very clear that the child's best interests have an important role to play. And indeed, of course, on the basis of authority, again, of this court, ZH Tanzania, they are and have to be a primary consideration. But as Lady Hale made clear at paragraph 26 of ZH Tanzania, the fact that they have to be considered first, as she put it, does not mean inexorably that a decision has to be taken in accordance with those rights. Sometimes a decision will have to be taken which weighs against those rights. Sometimes those rights will not prevail. Again, that's not new law. I appreciate that's very familiar to the case. The matter is perhaps put best by Lord Justice Sedley in the A.D. Lee case, which was approved by this court in KO, Nigeria, which we cite in our written case at paragraph 82. That's page 82 also of the core volume. Namely, that's what deportation does. Deportation does have consequences for other people. Of course, it's action which is directed and aimed at an individual who has done something usually of a criminal nature, which is wrong, not always, but quite often. But there will be consequences for the family members. That stands to reason. The Strasbourg court, similarly, has always accepted that that might be the case. We've cited in our written case the decisions of the Strasbourg European Commission on Human Rights in Jaramillo and Sarabji. For reference, the Sarabji case is in, I don't ask the court to turn it up, but it's bundle 4 of the authorities behind tab 45, and the Jaramillo case is behind tab 42 of the same bundle. In those cases, the court held that the British citizenship of a child who would be constructively removed with a parent who is being deported was not a particularly important factor. There are strong immigration policy considerations which militated in favour of supporting the removal decision. That's the same analysis that the Strasbourg court has adopted in the Butt and Norway decision. Again, I don't ask the court to turn it up now, but for the court's reference, that's again bundle 4, tab 40, beginning at page 1223, paragraph 79 at page 1239. So a consistent position adopted by the Strasbourg court there. So we said there's nothing in the point about not visiting the sins of the parent on the child. That's not the issue. The issue is that deportation occasionally has unfortunate consequences for other individuals, and those have always been accepted as being, in principle, acceptable depending on the facts in particular cases. That's the first of the 3 contextual factors. The second of the contextual factors is Mr. Sully's submission that the same test should be adopted for the deportation of a Zambrano carer with an EU citizen child indirectly, as is adopted for the deportation directly of an EU citizen child. And that's really another way of putting the Article 28(3) argument on imperative grounds of public security. Well, we say it's quite clear why there should be a difference there. Of course, the protection, as I've already shown the court in Article 28(3), is a narrower form of protection available only to EU citizens. So there's a primary objection in terms of trying to apply that to a third country national Zambrano carer in any event. But quite apart from that, the consequences for the child in each of those scenarios are different. Again, to pick up a point stemming from a question from my Lord Stevens this morning, in terms of the timing and the duration of an expulsion measure, a member state has to review at least an expulsion measure after 3 years. That stems from Article 32 of the Citizens Directive. The court's already seen that. I don't need to go back to it. So there's a possibility for member states to wait at least 3 years before reviewing an expulsion measure. With a Zambrano child, although if the Zambrano right is granted, it's granted on the basis that the child will otherwise leave, the departure may be short-lived. There may be, and I opened with this point, there might be a whole host of reasons why the departure is short-lived. It may be that after departure, there is a change in care arrangements in the host member state. If that is the case, the child can come back and there will be absolutely no objection to that happening. Equally, it may be that the child is approaching the age of 18 anyway, and so is approaching the stage at which they can travel independently back to the member state. They retain, in the meantime, all their rights as an EU citizen, and they can exercise them if it's possible to do so. And equally, one has to put that in the context of the fact, as I began with, that there are many reasons why parents might move their children from the territory of the Union to a third country. They may get divorced, they may split up, they may go in different directions, they may have to move for work reasons to do with one of the parents. Equally, children may be sent abroad for educational purposes. None of these things are particularly unusual or uncommon, but they all stem from the fact that a parent has parental authority over the child. As the Advocate General in the case of O put it, none of this, and the fact of EU citizenship cannot amount to putting a child under house arrest in the territory of the Union. We've set out that reference at paragraph 21 of our written case. You'll find it there. So for those reasons, we say the comparison with the direct enforcement of an expulsion measure against an EU citizen child is again inapt. The situations are really quite different. They have different legal and practical consequences. And can I just highlight 3 of those, which I've touched on already, but just to summarise. First of all, there's no direct interference with a child's rights in a Zambrano removal context, unlike the direct removal of an EEA child. Secondly, of course, a Zambrano child will not have exercised free movement rights before and may not exercise them in the future. So a very different legal context to the adoption of rights and to the granting of benefits. And thirdly, there's a point about the permanent risk of departure in any event for any child in the EU. I've already touched on that in some detail, so I won't repeat that. But for those reasons, we say there's nothing in that second textual point. My lady, my lords, that leaves me with my third and final contextual point, and really my final submission in the case. And that's Mr. Southey's argument that what this is all about is actually the right of a child to remain in their home state. Well, we say quite simply that is wrong. That is not what the Zambrano principle is about, and it's not what the CS line of case law is about. The Zambrano principle exists to protect rights associated with EU citizenship by ensuring that a child remains within the territory of the EU, not the territory of their home state. And as a very good example of that, one need look no further than the case of Rendon Marin itself. As I indicated when I summarised the facts, the slightly unusual facts of that case, the father was Colombian, he was present in Spain, he had a Polish daughter and a Spanish son. Can I ask the court to look at what the Court of Justice said about that factual scenario in paragraph 79? That's in tab 7, page 440 in the first volume of authorities, and paragraph 79. And the court will see there at letter E that several member states which have submitted observations have contended that Mr. Rendon Marin and his children could move to Poland, the member state of which his daughter is a national. Mr. Marin, for his part, stated at the hearing he maintains no ties to the family of his daughter's mother, who doesn't reside in Poland, and that neither he nor his children know the Polish language. In this regard, it is for the referring court to check whether, in light of all the circumstances of the main proceeding, Mr. Rendon Marin, as a parent who's a sole carer, may in fact enjoy the derived right to go with them to Poland and reside with them there, so that a refusal of the Spanish authorities to grant him a right of residence would not result in his children being obliged to leave the territory of the European Union as a whole. So one solution for Mr. Marin, which it was for the referring court to investigate on remittal, was whether or not he and his family could in fact relocate to Poland. And if that had been the case, the court was quite clear that, of course, that would mean he wasn't leaving the territory of the Union. And if he wasn't leaving the territory of the Union, the Zambrano principle wasn't engaged at all. So it's not, Zambrano is not and has not ever been about protecting a child's right of residence in their own home state. Mr. Sully developed that point this morning by trying to draw a distinction between the right of free movement and the right of residence. And he said Zambrano and European citizenship is about more than just free movement. It's about true citizenship. It's about rights of residence. But although the directive talks about the right to reside and move, the right to move and reside freely, the right to reside is not a right to reside in one's own member state, because one has that right as a matter of international law. And one will have that right domestically as a matter of the law of any of the member states. It's about a right to move and then reside in another member state. The residence is the consequence of free movement. And as for the principle about EU law, recognising the international law principle that states can't refuse entry or residence to their own nationals, that is recognised by the Court of Justice as far back as the Van Dyne decision, which was in turn recognised and adopted in this case in the FAM decision. That case is in, I'll just give the court the reference, Authorities Bundle 2, tab 22, page 662, 663, in paragraph 97 of the judgment of Lord Mance. Lord Mance there looks at the status of citizenship in a variety of different legal and jurisprudential contexts. Common law in European and international law, he quotes paragraph 97, Blackstone's commentaries. Then he quotes the decision of Lord Bingham in the Bunkholt litigation. And just at the top of page 663, you will see a reference to the European Court of Justice at letter A in Van Dyne, in which the court held that as a principle of international law, the state is precluded from refusing its own nationals the right of entry or residence. So, with great respect, Mr. Southey is wrong to say that when the directive or EU law refers to a right of residence, it's talking about a right of residence for somebody in a Zambrano situation. It's not dealing with protecting residence in a person's own member state. They don't need any protection from EU law in that situation. EU law is engaged because of the potential of not being able to move across frontiers and adopt residence in that sense after the move. There is more case law on this particular issue, which is not in the bundle, because we didn't quite understand the point to be put in this way. But in my submission, the court gets the assistance it needs from paragraph 97 of FAM, and that's why I've taken the court to that in response. My lady and my lord, may I just have a moment to do the modern day equivalent of turning behind me, turning my back for a moment? Very grateful. Is that right? Well, I'm very grateful for the opportunity. Ms. Smythe has quite rightly reminded me to give you the reference for where we deal with that last point in our written case. It's paragraphs 17 and 18. They refer to the cases of Aida and Rendon Marin. And Mr. Sully took you to the relevant passages in Aida today. We say that's a development of the idea of residence and movement from the initial Zambrano conception. See also, of course, paragraphs 28 and 30 of CS itself. Well, I think the only other matters that were dealt with in Mr. Sully's submissions were, first of all, the Brexit point. I'm very glad to say I think the parties are in agreement that there's no need for the court to deal with that at the moment. It may become relevant later, but it may not do, and I'm in agreement with Mr. Sully that could be dealt with if necessary by written submissions if the court was content with that. And then the only other point was Mr. Sully's argument about facts and proportionality. Well, of course, in our submission, there hasn't ever been any consideration of EU proportionality in this case, because the first tier tribunal didn't have an EU argument before it. The upper tribunal did, but thought that you couldn't derogate from the Zambrano right, so didn't look at proportionality. The matter would have to go back on remittal on any analysis to the tribunal to look at proportionality. And the court will have seen what the tribunal has said about the proportionality of removal under the convention, at least, and also some of the other factual aspects of the appellant's case. I don't propose to say any more about that now. I just flag that that's really a matter for fact-finding at a later date if that needs to happen. My lady, those are my submissions. I've not used all my time, but unless I can assist any further, that would be what I would propose to say in response.
Can I see whether there are any questions that anybody would like to put to you? No, I think that does conclude your submissions. Thank you very much indeed, Mr. Blundell.
Thank you, Melanie.
And I will return to Mr. Sully for your reply.
Thank you, my lady. All I was going to ask is whether or not it makes sense to have a 5-minute break. I'm quite happy to carry on. It's just I think my reply was scheduled for half an hour. That will obviously take us up to an hour and a half. And I know, unsurprisingly, the court has been concerned about people staring at screens. So
yes, I think that's a good idea, Mr. Southey. We will take a 5-minute break and return at 10 to 3. Thank you. Mr. Southey, now the moment for your reply, please.
My lady, thank you. Can I start? Well, can I address my learned friend submissions broadly in the order that he made them? The starting point in my submission is that CS is important, essentially, because it is a judgment of the European Court of Justice where it is answering an express question that was asked, essentially, about the criteria. And that explains in our submission why exceptional circumstances were used in that context and that they were not used in Rendon Marin. Now, my learned friend points to the reformulation of the questions that took place, and the court's seen those at page 505. But it's also clear that the European Court, or the Court of Justice rather, was well aware that, of course, under the UK Borders Act, as is recorded in the judgment at page 503, think it's paragraph 5, there is an exception to the rule essentially requiring deportation of foreign national criminals where deportation is inconsistent with EU law. And that's why the Court of Justice referred, as my learned friend fairly pointed to the legislation potentially containing a presumption. And that, combined with the questions that were asked in my submission, explain why, in contrast to Rend and Marin, there was express engagement with the circumstances or the factors that could be taken into account when deciding whether to deport an EU national, a Zambrano parent, and as a result deny an EU national child their rights under the Zambrano principle. So in my submission, there is an explanation essentially for why different language is used in CS in comparison in particular with Rendon Marin. My learned friend then essentially points to the structure of the judgment and says essentially if one looks at the reference to exceptional circumstances, the only prior reference to there being an exception or anything along those lines is paragraph 36. However, that fails to take account essentially of what is significant in my submission about the structure of the judgment, which is that what then follows essentially, having said there is an exception, is consideration of the factors that are relevant. And so one sees, for example, at paragraphs 48, reference to the family life of the child and private life of the child. Paragraph 49, one sees reference to the child's best interests. And all of that in my submission is the context essentially what follows in paragraph 50. And paragraph 50 is essentially, in my submission, a summary in very short form of what the conclusion is, essentially taking account of those various factors and the factors that have to be weighed in mind, which potentially weigh against the deportation of a Zambrano parent. So in my submission, one can't just say paragraph 50 is a reference back to paragraph 36. Rendon Marin, as I say, as I perhaps already touched upon in my submission, the answer itself says nothing about the test to be applied, essentially, when departing from Zambrano rights and when denying Zambrano rights. And the context of the question was essentially one that focused on automatic legislation. Now, my learned friend says it's significant in those two judgments that the language of Article 28.3 wasn't identified, wasn't adopted. But in our submission, there are several points about that. Firstly, the high threshold or a high threshold has been identified, maybe using different language, but a high threshold has been identified. It's been identified in the context of a case which, as I've already indicated, involves the court identifying factors such as the best interests of the child as being important. And that is clearly a key factor given the approach in ZH. And that is then consistent with Article 28.3 because Article 28.3 demonstrates how the European Union legal system recognizes the weight to be given to the child. And in one sense, the striking thing about CS is that although there is reference to the United Kingdom's government submissions about the directive, ultimately, what you see in the judgment is no express reference to the standards or to the Directive 2004/38. What one sees instead is the language of the directive being adopted in terms of there being a genuine, present, and sufficiently serious threat. Reflecting the fact that, of course, this isn't a context where the directive has direct application, but it is a context where very similar issues arise. So an analogy can be drawn. And that's why in our submission, we can point to the fact that Article 28.3 recognises that the rights of children are significant. My learned friend in that context refers to recital 24 of the Citizens Directive. That is the recital at I think it's in it's in the directive at, sorry, I've lost the page. It's at page 196. And that refers to the exceptional circumstances test. Well, it refers to rather the need essentially to protect children as a result of the links with their family in order to act consistently essentially with the UN Convention on the Rights of the Child. And my learned friend says that that demonstrates that Article 28.3 is concerned with family life, whereas Zambrano doesn't involve an interference with family life. Zambrano doesn't involve an interference with family life when the rights are honoured, essentially, but there is a family life issue, obviously, potentially, if the parent is going to be deported. And the family life issue arises for the reason I indicated this morning, because in practice, the child is left with a choice between remaining in their country of nationality without their parent, having to forge a link with a new carer, or remain or continuing to enjoy their family life with their carer, but then losing their right to citizenship, their primary right under citizenship, which is the right to remain within the EU. In the same way, a child who is facing deportation essentially faces a very similar choice. A child who's facing deportation where Article 28 applies is in a very similar position, because again, the child in that case is put in a position where either their parents move from the state where they have based themselves, accompanying the child, breaking their own links with that country, or they stay and then family life is disrupted. In both cases, the family have a very similar choice to make. Do they stay together, meaning that some people are forced to move from the place they've based themselves in and where they may well have rights to remain, where they like to have rights to remain, or do they separate? So this distinction my learned friend draws based on the recital in my submission isn't a good one. And actually, the recital supports our argument because it demonstrates how the origin of this high threshold is essentially the UN Convention on the Rights of the Child. And that, as you've seen, because I drew attention to Baroness Hale's judgment, that convention, or the rights that are derived from that convention, recognize the importance of being able to remain in one's home area. My learned friend also says it's significant that Article 28.3 only effectively permits removal on public security grounds, whereas the case law here refers to public policy. But that doesn't mean that doesn't mean that one can ignore the fact that effectively that there is a recognition, say consistent with the UN Charter, that there is a high threshold where children's rights are an issue. Turning then to KA, my learned friend says there's no hint of exceptional circumstances in the test identified in KA. But KA, one goes to paragraph 97, which is at page 376 of the core bundle. KA, without in any way suggesting that CS is wrongly decided, there is no suggestion that CS is wrongly decided, and indeed CS is cited repeatedly earlier on at paragraphs 91 to 94 of the judgment. KA uses different language, but it does use it uses language which makes express reference to both the best interests of the child and the fundamental rights enjoyed by the child. CS doesn't make, in the concluding remarks, the paragraph 50 and the answer to the referring court's question, it doesn't make express reference to the best interests of the child. It just talks about the need to consider various interests. So in my submission, the way of reading those two conclusions together is that what KA does essentially is identify best interests as being a key factor, and identifying the children's fundamental rights as being a key factor. They are factors for the reasons set out in ZH that are likely to carry particular weight in this context because the child is being denied their rights as citizens. But those are the same factors that are essentially summarized as requiring exceptional circumstances in CS. Turning then to the context, the Maloney and Friends submissions about context. Maloney and Friends says, although we're entitled to point to the passages of ZH, for example, which talk about children not being blamed, that doesn't necessarily mean, and there's no dispute about that, that a decision always has to be consistent with a child's best interest. Obviously, we accept there can be circumstances in which a child can be deported in a manner that's contrary to their best interest. We also accept there are circumstances where a child's parents can be deported in circumstances which are contrary to their best interest. But the key point about best interest is that it explains the high threshold. And Maloney Friend, to put that in context, Maloney Friend in his submissions today several times talked about the difficulties and the high threshold involved in deporting an EU national generally. Well, that may be a fair summary of how EU law works. But that doesn't mean one doesn't also need to take account of the particular position of children. And this is where Article 28.3, for example, comes into play, because what it demonstrates, consistent with the Charter, and in particular Article 24, is if there is generally a high threshold before you can deport an EU citizen, there's a particularly high threshold before a child essentially can be either deported or what might be described as effectively deported because of what is happening to their parents. And that's the context of Jaramillo and Butt, two European Court of Human Rights authorities that Maloney and Friend referred to. Maloney and Friend says, look at the approach of the European Court of Human Rights, which demonstrates essentially that deportation that results in the effective deportation of a child is not objectionable. But as I pointed out this morning in opening, the Charter of Fundamental Rights, for example, makes it clear that the European Convention is a floor, not a ceiling, in the context of EU law. And that's important in this context because, of course, what Ruiz-Zambrano onwards demonstrate is that what one is concerned with here, primarily the starting point here, is that the child enjoys a right of citizenship under EU law. That is not what the ECHR is concerned with. The Council of Europe doesn't have an equivalent concept of European citizenship. And so the approach of the European Court of Justice, rather, the CJEU, it's quite clearly conditioned by the fact that citizenship and EU citizenship is in context in this, is an issue rather in this context. And my learned friend says there is a difference essentially between the situation where an EU child, an EU national child, is being deported, the sort of situation caught by Article 28.3, and Zambrano. But if there is a difference, and there are differences, I think I'd have to accept that. But the key difference is the fact that in this context, what is happening, unlike the situation of the child, EU child being deported rather in accordance with Article 28.3, is the child is being denied all of their EU rights. They're being excluded from the territory of the EU as a whole. That's why Zambrano rights arise. And that's where the sorts of ZH factors come into play, because just as ZH identifies, we would say correctly, the sorts of factors that mean a child shouldn't be deported from their home state, similar sort of factors arise where a child is at risk of being removed from the EU as a whole, because similar sort of benefits flow from residence in the EU. The fact that one can essentially be brought up in a society that reflects one's status as a citizen. That is the right one enjoys when one can reside, and that is the right that one loses when one's parents are removed in circumstances where you have to accompany them. And my learned friend says the second difference, or a key difference, is essentially departure of a Zambrano parent may cause the child to depart for a limited period of time. That's true in principle, but equally, unlike the Article 28 child, the child who was exercising free movement rights, a child may be deported essentially through the Zambrano route, or may be effectively removed via the Zambrano route, without having any real right of return for many years. If the child is young and their parent has no right to apply to return, then they may well be unable to return. And unlike the Article 28 child, there is no express right for the Zambrano parent to apply to re-enter. There's no suggestion that, for example, the lengthy periods during which rather a deportation order applies are inconsistent with EU law. Millennium Friend says, well, in any event, the child may be moved by their own parents, and EU law doesn't prevent that. That's true, but that would also apply in Article 28.3. The child who is exercising free movement rights may be moved by their parents, and there's no suggestion that the child can then sort of rely on Article 28.3 to prevent their parents moving them. The critical point in both those cases is, if that happens, it is the parents, in accordance with normal principles of parental control, who've decided that the child must move. And it would obviously be wrong for any sort of form of law effectively to interfere with that, save in very limited circumstances where family law would potentially apply. Finally, my learned friend says that child may not have exercised free movement rights. That's true, but that's why we go back to the point that, as this case law has clearly identified, EU citizenship is a fundamental status. The fact of the matter is, EU citizenship brings with it, essentially, certain benefits, including residence within the EU. And then my learned friend says the right to reside, for example, in the UK, if you're a UK national, arises under domestic law. Well, quite clearly, there is a right under domestic law to reside in the United Kingdom. But as FAM makes clear in our submission, there can be overlapping rights. The approach of Lord Mance in the passage my learned friend referred to essentially was to say, well, UK law gives great weight to citizenship, so it's very difficult, very unlikely EU law doesn't give gives greater weight. But that doesn't mean EU law can't give rights or can't protect rights that are protected as a matter of domestic law. And remember, in S, it was expressly said, paragraph 24, that EU rights can be enforced against member states. And if it wasn't the case that there is some right essentially to reside within your own member state, it's very difficult to see how Zambrano would operate essentially, because Zambrano is by definition concerned with the situation where children have not made use or taken advantage of free movement rights. So Zambrano has to be based on the idea that there is a freestanding right of residence, because that is all the children in question have exercised, and that is all they are potentially at loss of doing. And that's the context also of my learned friend's final submission, which is to say, look at Rendon Marin and essentially the fact that the court left open the possibility that it might be open for the children in that case to be required to move to Poland, because one of the children was Polish, as a way of safeguarding their EU rights. Now, the first point I'd make about that is none of that is inconsistent with the basic point we've been making, which is that EU citizenship is a key concept. And nothing that Baroness Hale said in ZH does not apply equally in our submission to EU citizenship. The EU has a distinct identity that's obviously been part of the European project, and what clearly Zambrano is about safeguarding that right essentially to have an upbringing within the territory that one has citizenship of. And that's what ZH is about. Maybe a different type of territory to the nation state, but still that doesn't change the fundamental point that the best interest of the child suggests it is important that a child is brought up in an area that effectively is part of the territory that they have citizenship of. But secondly, in any event, all the European Court of Human Rights said in Rendon Marin is this is something that may need to be looked at. It did that in the context of a judgment. See, for example, paragraph 81 that said one needed to take account of family life and best interests. So it wasn't saying essentially the potential for a move to Poland is a sort of trump card essentially, and justifies what Spain is proposing in this case. So it's just saying it's something that needs to be looked at. Now, in doing that, one would presumably need to take account of, given the nature of, or given the rights rather protected by the Charter, one would need to take account of factors such as the ties the children enjoy with Poland, the ties they enjoy with Spain, and whether by doing that, one was essentially interfering with their best interests and family life. So it's not saying the sorts of factors that were identified by ZH become irrelevant in this context, far from it. There's no reason to believe they wouldn't equally be relevant when looking at whether the child should move from Spain to Poland. It's just saying that may be an answer, because ultimately that is a way in which the children continue to enjoy their rights as EU citizens. I should say finally, my learned friend, I think, argued that whether or not I'm right or wrong to say that there's a high threshold in this context, and obviously I argue still that there is a high threshold for all those reasons, and in particular because of the importance of taking account of the best interest of the child. My learned friend's argument was, in any event, remittal was required. In my submission, if it is correct that there is a high threshold, there has to be some factual basis upon which it could be concluded that threshold could be crossed. And here, given the period of time without any offending, there is simply no factual basis for that, which reflects the fact in our submission that the threshold set by the European Court of Human Rights didn't properly, sorry, not by the European Court of Human Rights, by the Court of Appeal, didn't properly reflect the high threshold that applies here, taking account of the best interest of the child. There simply was no evidence to justify a conclusion that threshold would have been crossed. Well, lady, can I turn, there may be a little delay because I think, because of the broadcast delay, there may be a little delay. Can I just turn to my WhatsApp to see whether or not I'm getting the equivalent of a note passed from behind?
Of course you can.
Thank you. Lady, while I'm just waiting for that, can I just mention one other thing, just a procedural thing? Maloney and Friend said correctly that we both agree that the issue of the UK's withdrawal rather from the EU is something for another day, possibly, and that remains the case. I think Maloney and Friend said we both agreed that would necessarily need to be done in writing. I think I'd reserve my position on that, depending quite on what happens and how significant that potentially is. And I'm not sure at this stage, because none of us know what the implications are. I'm just not sure I would agree that it necessarily can be done in writing.
Thank you.
I just, while I was saying that, have a WhatsApp message saying that there's nothing to add from those behind me. Thank you.
Thank you very much indeed. Well, unless there's any more questions from anybody, and I don't see that there's any indication that there is, that concludes matters. It only remains to say how grateful we are to Council and everybody who we know has been assisting them as well with the case, for the assistance that we've had today from your very able submissions. Thank you very much indeed.
Thank you, Melody.
Thank you. Thank you.